take all sorts of points. We cannot, or rather, we cannot stop you. But the thing is, in considering the background of the case,
Absolutely correct, my lord. I have
you
gone through the
talk with
records.
your officer.
My lord, I shall talk to them and
Lordship, in my respectful submission, Lordship, one thing can be considered, Lordship, in the sense, Lordship may kindly see the conduct, Lordship, one thing that everybody.
Madam, we have requested the
Yes, Lordship.
Deputy Solicitor
Lordship.
General. He carries weight. He is holding a substantive
Lordship,
post under the government.
Lordship.
He's almost the highest official of the state, or
Absolutely.
rather the Union of India.
Lordship.
So we have asked him if anything can be done. In the meantime, you sit in the test. If you get more than 50, then all the
all
problem
problem will be sorted. All
Lordship,
problem will be
the problem goes. And if you do not get, then we will consider the contempt application on merits. When he says that on 10th we have fixed that you appear, we have
Lordship,
given you.
Lordship remembers that I had no other option but to sit for another
Madam,
test.
you want the job.
Yes, Lordship.
Want the job?
Yes,
Let
Lord.
us see.
Lord.
You appear in the test. If you hopefully get more than 50, then there will be no problem. And we have asked Mr. Mojumdar to see also that whether they considered the background of the case. Ashok, Mr.
না না ওভার আনি 10 তারিখ আছে 10th of December
Mr. Mojumdar, learned deputy. Yes.
This is my appeal, my lord. The writ petitioner is aggrieved by
TIT.
shift. The order was passed. My lord, just division bench of Honorable by Lord Justice Showman Shen. If I remember correctly.
Oh, আচ্ছা ঠিক আছে 9-11 জুন
My lord.
এটা হচ্ছে লিস্টে কোনটা দিয়েছো ক্যান 2
Can 1, can 2 দুটোই আছে ওটা লিখে দেবেন।
records reveal that the application being which is the order impugned
My lord, the order impugned is the learned single judge's order of 29 January 2025. When my prayer for pay protection as well as considering my past service was declined.
Hmm.
I
You are still in service.
no, I have retired.
Your pension has started.
No, I am declined the pension because holding that I have not done 10 years service in the state aided government school.
No, you have been sanctioned granted pension.
I have not been granted pension.
No,
Background
you
is
that I declined to take the benefit.
no, not declined. They declined to give me the benefit.
Right.
I did not decline.
On a plea that you have not
My-
attended the qualifying service of 10 years.
Qualifying service of 10 years, disregarding my services I gave in the municipal school, Asansol Municipal School, holding that those were not approved service.
Qualifying service না ওটা করিনি। There is a government circular to take into account that service.
State is the answering respondent. State is not appearing. Board has nothing to do with
Have you brought that circular?
My
We
lord,
have we have delivered a judgment relying upon the subsequent circular of the state.
Recognized, aided or unaided, service rendered in recognized aided and unaided school shall be taken into
Taken into
account.
account.
Have
And
you ever brought?
he will be covered by that.
There
Have
is
you brought
another
this?
judgment of Justice Girish Gupta, Lordship. Please
I
take
will
up.
find out, my lord. I'll find out.
Now, when did you attain the age of superannuation?
I have attained in 2021 I retired. My lord, the background is I am working in since 1987 in the Asansol Municipal School. In 2012, the government issues a notification, the West Bengal School Service Commission, for regional level selection test for recruitment in the post of headmaster. I apply in that, I qualify. In 2014, I join as a headmistress rather, she joins. But immediately thereafter, Lordship, I apply for the pay protection. That was declined. I filed my first writ petition. The order of that writ petition is at page 50, my lord, of my application.
Now, when you appeared in the selection process for headmaster, headmaster has an eligibility criteria. 10 years.
Yes, yes. And that is in an approved school. That is the criteria. Now, when
Then why the court held against you?
Court is holding that approved criteria and the school of under the
Give us 2 minutes.
Lordship. Paragraph 6 is the
আমরা ওটা অর্ডার পাস করেছি এটা।
Lordship kindly sees the condition. It was approved service. Now, when state declines,
just on. Under the Commission Act, approved service is defined.
no, it's not defined.
Under the West Bengal, your previous school was affiliated to any board?
In a municipal school. It's a municipal school recognized
By?
under West Bengal secondary education.
Recognized under West Bengal
Secondary education, but it's a municipal school.
Very good. In the West Bengal Secondary Education Act, approved service has been defined somewhere. Subject to correction.
এখানে তো পাওয়া যাবে না।
Approved service means post is to be approved. Post is to be approved by the DI.
My lord, under
Post is
West
not
Bengal's
Post.
West Bengal Secondary
Suppose
Education
if
Act,
teachers.
No, I
Any
just
posters approved.
wanting to know if there is a.
It was an
In the previous round of litigation, what happened?
in the previous round of litigation, Lordship directed, Lordship,
Relegated for consideration.
yes, kindly sees,
Acha, municipality school, which period to which period you worked?
my lord, I was from 1987, 4th August 1987 till 11th July 2014. 2nd August 2014 I joined. Sorry, my lord. 2nd August 2014.
2nd August 2014.
So it was nearly 13 plus 14, 27 years of service there.
কিন্তু বাড়ির একটা মামলা যেটা ওই সেটাতেও এই রাইটার অ্যাড করেছিল, সেখানে আমরা একটা স্যাটিসফাইড ছিলাম না। Determine. He has to come with that.
Lordship, may kindly see page 50, 50.
Where is the state, Mr. Government Leader, Mr. Dotto? You can appear in this matter. Nobody is appearing on behalf of.
I'll have a copy.
Heard Mr.
This is the
Heard Mr. Mukherjee learned Next.
My lord, this matter, my lord, I am for the appellant.
My lord, I am appearing on behalf of Union of India. My lord, no copy of stay application has been served.
My lord, I am for the university, my lord. No
On
copy
last
of-
occasion also I mentioned that no copy has been served till date. No copy of
Or it
stay
was
application.
served, affidavit of service was filed. I filed affidavit of service also.
Since my engagement, my lord, by Honorable
I am
Justice
handing over a copy,
oriented
my lord. He has a very little role in this matter. This is the extra copy I am serving.
just now.
Service has been effected long back, affidavit of service has been filed. It has not been sent to him by his client. So that for that reason, I am not responsible.
Yes, Mr. Dutt. What?
Lordship. My lord, before I open the case, my lord, I just give a lordship the
Substitution হয়ে গেছে।
I think it will. I think it will. 4 পাতা বাজিয়ে দিই। খরচা হবে বলে।
খরচা বাঁচাচ্ছেন কেন ক্লায়েন্টের?
No, no, no. আমার client খরচা বাঁচাচ্ছে। আমার client তোমাকে পাঠানো হয়ে গেছে।
আসেইনি,
জিজ্ঞেস কর।
আসেনি।
Who is the read petitioner? And you are Union of India. You are for the university.
All are here, my lord.
Yes, Mr. Dutt.
Lordship, my lord, in a nutshell, my lord, I just give a lordship the background of the case. Where the read petitioner in this case was an employee of a project. Now, my lord, I'll one after the other, I'll show certain documents to establish. Now, my lord, the university, in its wisdom, in breach of the statutes, the Bidhan Chandra Krishi Vishwavidyalaya Act, and also the Control of Expenditure Act, have purported to take them into the regular establishment of the university. So this is precisely the case. Now, my lord, the law is well said. This is the kind of backdoor entry which is not permissible because it is without the prior approval of the government. This creation or appointment cannot be made. You'll also heard this matter for some time last occasion. Now here, my lord, if I
Didn't hear, Mr. Dutt. We didn't hear.
no, my lord, for section 5.
Oh, আচ্ছা।
Lordship, kindly, this is the background. Whether this absorption or the bringing in the regular establishment of BCKB, the BCKB could do it in breach of statutes, the University Statute, as well as the Control of Expenditure Act, 2006. I'll come to that. Lordship, kindly sees how he was appointed. I shall try to be very brief. Kindly have a look to page 69 once. The appointment letter of the writ petitioner. I will start from here because Lordship, kindly have a look to page 69. Of the stay petition. Lordship, got it? This is 12th of January 84. Right hand top. 12th January 1984. It is handwritten at the top right hand. This is the Bidhan Chandra Krishi Vishwavidyalaya Registrar's Department. And while the project is 100% government, central government funded. This is very vital. The project is 100% central government funded. Now, if I place the letter of appointment, page 69, in terms of the resolution of the Executive Council of the 22nd meeting held on 13th January 1984, Sri Dilip Kumar Sharma, son of Swanso, is hereby offered appointment to the temporary post, Lordship kindly says temporary post of fieldman under the project entitled Comprehensive Scheme, that is cost of cultivation of principal crops of West Bengal for implementation under the Vishwavidyalaya. So, this Vishwavidyalaya is the host university. Through the university, the project will work. So it is actually in the scale of so and so and on the following terms and conditions. Initial pay in the scale of such and such will be fixed at so and so as per rules plus allowances as admissible under the rules. Then The post will be purely temporary, B, small b, and may be terminated by 1 month's notice. Then next sentence is also very important. Well, page 69, your lordship, page 69.
Yes, yes.
Then B I was reading, small b at page 69. No assurance can whatsoever be given regarding continuation of the appointment beyond the period for which the project has been sanctioned. Lordship kindly seeks, this is the appointment in a project. Post university is BCK. And here the temporary post, repeated, is purely temporary, then temporary post of fieldman. Fieldman. Followed a confusion has been created later on. There is a regular post of field assistant in the university. So at times it has been this camouflaged, or that fieldman and field assistant more or less is not that. So the appointment is to the post of temporary post of fieldman in a project. Post university is Bidhan Chandra Kishore Vishwavidyalaya. And then no assurance can whatsoever been given regarding continuation of the appointment beyond the period for which the project has been sanctioned by the appropriate authority or absorption in any permanent or temporary post in Vishwavidyalaya. Clearly it is mentioned that this is no assurance. As if the project comes to an end, the offer will also come to an end, as if. And that's why it is specifically mentioned this will not, no assurance can whatsoever be given regarding continuation of the appointment beyond the period for which the project has been sanctioned by the appropriate authority or absorption in any permanent or temporary post in the Vishwavidyalaya. Then, my lord, you are required to serve anywhere. Then, D, the terms and conditions of appointment will be governed by the provisions of Bidhan Chandra Kishore Vishwavidyalaya Act 1974. Well, I'll take your lordship to the act, but here lordship kindly sees the terms and conditions of appointment will be governed by the provisions of the Bidhan Chandra Kishore Vishwavidyalaya Act 1974 and Amendment Act 1981, ordinance, statutes, regulations, and rules framed thereunder and resolutions of the appropriate authority of the Vishwabharati. Now, my lord, clearly the terms and conditions will be governed by the Bidhan Chandra Kishore Vishwavidyalaya Act 1974. Now, my lord, this is lordship. I just placed the facts. Yes. Then, my lord, the F. I'm omitting, my lord, not very relevant at this juncture. F. His selection in the temporary post of fieldman is conditional that he should produce a certificate of medical fitness before joining. So, my lord, again, my lord, repeatedly it says temporary post, temporary. At least thrice, 4 times is stated. Is conditional that he should produce a certificate of fitness before joining. The assignment for which he may appear before the medical officer of the Vishwavidyalaya, MISON Kolani. If he is agreeable to accept the offer of appointment on the terms and conditions and the scale of pay, he may join the post within 15 days. And he accepted and he joined thereafter. So, my lord, they accepted these terms. Now, if I take your lordship to
So why did you when did the project come to an end?
Well, the project has continued for years.
So, Mr. Dotto, this point was not taken in any of the governing body meeting where your nominee is there, that you are continuing a person, ultimate burden will come to the state.
Well, this lordship kindly sees that
you extracted service from 1984. Now, when he has attained 60 years, you are saying you will not get pension. Government.
That's the case they have made out in the writ petition.
And you have given to other similarly situated persons under the same project.
My answer is very simple. There cannot be any negative equality. There cannot be. There is well settled. Well, I'll cite a judgment. At least one judgment I'll cite today itself. Now, my lord, lordship kindly sees. Yes, that's one aspect of the matter. There is another aspect. Lordship kindly sees that if it is governed by the terms and conditions of Bidhan Chandra Kishore Vishwavidyalaya, what the Act says, 190, lordship takes, my lord, page. My lord, the participation of a government nominee in a meeting doesn't partake the character of the government sanction or approval.
Right, you are right, but you have done so. It is not that any expense is covered by the finance department just for because a person was a nominee. You also know that.
My lord, Lordship kindly sees.
These people are conscious that we are disbursing this grant. We will face the problem later.
No, my lord, the grant, my lord, in a different context. Lordship kindly bear it for some time. My lord. I'll just place one after the other. My lord, Lordship kindly.
Now,
Kindly-
what has the learned single judge directed? Disburse the pensionary benefits.
Yes.
Any contempt you preferred?
My lord, this.
This was decided upon affidavits, writ petition.
Yes. Yes. Everything. Everything. Lordship, my lord, this is. Huh? এইটাতে না এইটাতে
Common test.
My lord, the
Some
what
are
is about?
under salary, vacancy post, some are saying otherwise. Which
সে তো কৌশিকের অর্ডারে বলেছে
You have not been served. University.
State petition, I have not served.
আরে
State copy টা পাই।
সার্ভিস
University has not received
I don't
the
know
state
what
petition.
is happening.
Yes, served upon you, madam.
Well,
Well,
maybe
Mr.
current-
Tohmadin
I
is
have
not served. I see it has
Not
sent
that
to him.
you are
I have sent by registered post to Delhi. His client has not forwarded him a copy. Only 4 papers have been sent to him. He says it has not been served.
how do you proceed? Don't proceed with the contempt, then we fix hear it out, how hear the matter finally.
Kindly fix a time for the matter, my lord. This person has already expired, my lord. Now for the family pension,
Oh, person expired.
Yes, sir.
my lord, the original writ petitioner
When did he?
after delivery of the judgment.
Oh,
ও তাহলে তুমি
Now
একটু
it's only
subscription করতে হবে তো।
subscription হয়ে গেছে।
Subscription হয়ে
ও,
গেছে।
sir, yes,
It's only for
subscription-
family pension.
Affidavit সার্ভিস তো ফাইল করা হয়েছে তো।
আধা দেয়, আধা দেয় না। অর্ধেক দেয়, অর্ধেক দেয়
এটা
না।
বাজে কথা বলছে আপনাদের ইউনিভার্সিটি।
তা আমরা কি করবো? অধিক কথা বললে
Well, the affidavit of service is there. Kindly have a look.
when can you file the paper book, Mr.
Paper book, yes, I can. কতদিন লাগবে? 2 সপ্তাহ তো লাগবে।
You file it by 24th of December.
Yes,
That to
that
be
will
vacation.
do. Yes, but not
That
in
fee.
this the next year. It goes to next year.
We will fix it up on a particular date.
Yes,
And
as your
till
lordship.
such time he will not proceed in contempt.
Yes, Master. Well, the affidavit server, they are saying, I don't know how they are saying.
You prepared the
Serve them.
prepared the paper book, give a copy to.
That's the yes. That's I have to.
that is 50% stop.
But no, it's not correct to say that copies have not been served.
আপনি help
হাত তো লাগে
But Mr. Dotto, you have a burden to discharge.
This case, I am fully ready. I'm fully ready, even today. I'm fully ready to argue the matter and complete it. Here, the direction is upon the university.
Take steps upon your government nominees. These persons attend the meeting, they don't give a dissenting note also that what you are doing will be against the interest of the government. And today you, the government leader, you are bringing
Yes.
interpretation about nomination of a member.
Yes.
So how incorrigible, see these officers. In finance department will sanction any amount from the government. All directions of court, finance is under consideration. And see what finance does.
And Maladi, this is a very, I mean, the task is heavy upon me. But here, Maladi, in this case, the direction is upon the university to pay, not the government.
Then
Because-
don't prefer appeal, they will pay. Don't prefer appeal. Yes, on that count, we can dispose of the appeal, that there is no burden
Let us
upon the
wait for
state.
6th of January.
No, we will record that there will be no burden of the state in view of the order passed by. We will interpret the order. Let the university suffer. Let the VC come in contempt. Do something, Mr. Dotto.
Here,
I can give-
directed the university to pay the pension to the petitioner.
Why, my lord?
yes, because Mr. Dotto, whatever we have seen all the municipality appointments, all municipality appointments. ROPA 92 given, ROPA 90 benefit given, ROPA 98 benefit given, innumerable meetings held by the government nominees in consultation with the municipalities that yes, he's working. Yes, approved. Now, when his retirement comes, the sanction goes to the state. What will finance department say? Finance will automatically raise an objection that there was no sanction post, no sanction vacancy. Why should government be burdened with this financial liability?
Or without the approval of the government, therefore.
No
So then-
approval was taken at the time of appointment. Appointment was in the 80 or 90.
See, now what will a court of equity do? Tell us. Court will shut its eyes. Court in exercise of equity cannot shut its eyes that you have extracted
True,
service, everything
true.
done.
That is
Provident fund, such and such, all account was open. Certain amount has been deducted from his salary every month. In this case also, I think.
Mr. Dotto,
Now-
you see the yearly budget allocation of state. Towards interest payments, state spends crores of monies. All education interest matter, 8% interest.
now it is reduced to 6, I understand.
You are happy for that?
So we are not recording that. You give a copy to the learned council of the university.
Will copy
Give a
there?
copy of the.
একটা দিয়েছে তো।
She is claiming that he has not received.
It will be given to her.
Yes.
It has already been given, Malar, but
Again,
for the second
once
time
again.
I'll be giving.
Once again, court can
Get
direct
the
press
video
service.
copies of the pensioners who are your colleagues in that system. Bring the PPOs. And if you can get 1988 ROPA fixation, there is a memo which contains the signature of both the university and the state. You can bring. Look into it. Yes, next.
Malar, the item 6, Malar, more or less the same matter, Malar.
You are there, Mr. Banerjee.
No, Mr. Chatterjee.
6, my lord, I'm university.
Well, they
Who is
same
the,
order will come.
item 6, who is for the appellant?
Mr. Chatterjee.
Appellant most Mr. Dotto.
Oh, who is for the
It is the appellant.
And who is
And the-
Union of
I'm the appellate, I'm the writ petitioner.
writ
I'm the
petitioner?
appellant, Malar. I'm the appellant.
Item 6.
Item number 6.
I'm item 6, I'm the writ petitioner respondent.
That also decided on affidavits.
Yes,
No, my lord.
Affidavits, but more or less, Malar, the
Well-
points of law are almost similar in that matter.
here,
But
my lord,
it-
I'm covered by the death cum retirement benefit regulations. The definition of pensionary service includes my case,
Mr. Chatterjee, we have fixed that matter on 6th of January.
but they cannot be heard together. They can be heard one after the other, but not together.
But some points are almost
But
similar.
not all points.
All right, very good. You have filed any contempt application?
That already order is there, that I'll not proceed with the contempt.
That order is all.
Chano.
Just you are in item. Who is in item number 4 and 5?
4 and 5 are
Just 2 minutes. We take a
2
seat.
minutes, my lord.
And the other thing is, my lord, the employer share of contributory provident fund was taken back with interest.
Employer share of provident fund নিয়ে নিয়েছে ওটা।
In terms of the DCRB, my lord, and let that money be secured in the meantime.
State reports.
In that case, my lord, the report was filed. Report in the form of affidavit.
Yes.
More or less, my lord, the law points are almost same. Facts are a little different. Right?
But the other distinguishing feature, my lord, I'm a teacher, he's a non-teaching employee.
আচ্ছা মিস
We have been informed that is another appeal
But the order already that they will not pursue the contempt is already there.
That is there, Mr. Dত্ত. না দেখি বাবা, তারপর আবার কোর্টকে বলবে দেখে।
I can move the contempt in January.
He earlier ordered, he said, Mr. Chatterjee assures this court shall not proceed with the contempt application in the meantime.
In the meantime means
আজকে শেষ হবে।
আজকে শেষ হবে। In the meantime goes.
আচ্ছা এই লাইনটাও অ্যাড করলে।
এই লাইনটা
Chatterjee
assures.
assures before this court that the petition respondent number 1 shall not proceed with the contempt application till the disposal of the appeal.
Till January end. In the other matter, my lords have said
Until the
January end.
end of January or until further order, whichever is earlier.
Yes.
Lordship grateful.
Acha, Mr. Mitro, your brief, this is that fake certificate.
Yes.
Acha, where is that Justice Chondo in another matter directed a criminal investigation report to be filed?
Lordship,
Can you show us that report?
Lord, report has not been handed over to us, Lord.
But it is kept on record of that.
Yes, but
matter.
it has been handed over to the
Do you have it?
honorable court.
You have it?
We have.
No, in the other
Yes,
matter.
another matter. Report we have.
You have, but you didn't place that before us.
No, it is not there.
No, report
On the last occasion, I just shown, my lord, if your lordship, my lord, can you take the order? In the order, my lord, the report has been quoted. The order of Justice Chondo, my lord, the 15th of September 2023.
That is not with us.
Order is,
Kindly see Justice Chondo's orders.
you have the,
No, you have given copy.
now, my lord, if your lordship, my lord, can you see?
Report is kept on
Yes,
record.
kept with the file a report before this court on 23rd of August 2023. A copy of the report was made over to the parties. Yes,
That you have.
yes, I have. But today I don't have, my lord, but I have the copy.
So please, we want to go through it once. যেটাতে similar matter করতে দেন, no করে দিয়েছে। এটাতে একটা criminal investigation report ফাইল করে। যখন ফাইল করে যেখানে অনেক criminal investigate filed a report on it. Whichever the business is decided to issue us. Body learned Mr. Mitra, your office, your university must be knowing about that.
Yes.
In that, seeing the report, you yourself submitted that I will.
But I will try to procure it from the university.
No, not procured. If that is the stand of the university, why you are not taking that stand in this case? If they were students of the same year, if
Not
both had applied for review, because your allegation is that there had been a fraud practice by the university officials for which we have initiated a proceeding.
Not sure.
Just let us see that,
Not
because he has got already an appointment. Once we pass the verdict, his appointment goes.
Not sure.
Development.
I appear for the appellant, Your Lordship.
Opening for the
Kindly-
university. Bengal.
Kindly have a look at Your Lordship's last order, 28th October
Sir,
2025.
don't pray for it.
No, I'm not doing.
28th October 2025 order, and before that, 30th June 2025. Two
What
orders.
wrong did we do?
There was a direction by the Honorable Coordinate Bench to আজকে টাইম টাইম চাইছি না, তুই শোনার আগেই তো বলে দিলি, তো প্রচন্ড জাজমেন্টাল না তুই রিপোর্টটা matter, my lord. I am not assisting in this particular
Then who is his junior in this matter?
but I cannot say, my lord. Over phone, Mr. Sen requested me to. I am in this matter for the state, my lord, but not for the education department. I am there. Mr. Sen will appear for the state, and perhaps he has the document. I don't know, but kindly, pass it over. I am not praying for adjournment.
Sit over. Once he comes, he may not be there.
At 1 p.m. Can it be your lordship's convenient or 2 p.m. my lord?
We are keeping it on Monday. Tell Mr. Sen that if the report has not yet come, to take appropriate steps in the meantime.
On Monday.
On Monday we are.
Your lordship, kindly pass a one-line order, makes it a peremptory direction.
How many times you will direct? Let us see. When Mr. Sen is there, we told him. We
But
also.
on the last occasion, I am also convenient, my lord.
So if he is in difficulty, let no further time be taken.
But today he is ready with the matter, but praying for short passover. If your lordship suits,
The report has to be filed on us. We have to go through that report.
my lord.
Yes, next. If you have come with a report, then give a copy in the meantime. There is no
My
problem.
lord, I will talk with you. I will, my lord.
Yes, next.
Yes, I should be speaking on Monday. Great.
Seven, my lord, I am appearing for the respondent college services omission.
Your Lordship, I appear on behalf of the appellants. I just wanted to indicate that the impugned judgment has been passed by Honorable Justice Chatterjee while he was sitting in single bench. So I'm praying for.
The order impugned in the present appeal has been passed by one of us. Oh my God.
extension of recommendation.
16 তারিখ রেখে
Grateful to you.
Grateful.
I am appearing on behalf of state respondents.
Yes. On behalf of the London Advocate Ali Hassan Alamgir, Lord, sir. I'm
Madam,
paying
you mention matter listed and you do not.
My lord, the senior advocate Pratik Dhar is also engaged in court number 18 for
We are
this
so
case,
happy
madam.
to learn that, madam. You people are busy.
No, my lord.
Every day you people are busy. Not today.
Again, I am appearing on behalf of the petitioner, Lordship. Yesterday, Lordship, directed
Yes.
to serve upon the Lordship
I'm appealing for the state, my lord.
SSC, Lordship. I have already served.
Hmm?
SSC, Lordship.
Fileটা দেখি তো।
Lordship, it's a
Come this side.
matter.
Come this side. You come this side.
Lordship, matter relates to the appointment of.
But I had called up Dr. Patro yesterday. He is aware, my lord. I think he will come running. ওই তো এসে গেছে আমার ব্রিফটা এটা তো আমার মামলা আমার এটা না না the honorable trial judge has denied the relief, putting that I have approached the court after, my lord, the time. My contention is that
Just.
আচ্ছা আচ্ছা এক্সটেন্ড করেছে আপনি তো
আমরা দিকটা চলে যাই ঠিক আছে আমার বোনের সঙ্গে আছে সুবিধা
সময় দিবে নোটিফিকেশন তো
Yes.
থেকে শুরু হচ্ছে যেদিন হচ্ছে সেরকম ফার্স্ট নোটিফিকেশন ওরা
Yes, tell us, Mr.
my lord, it has been submitted, my lord, kindly paragraph 11. What was the stand of the commission? The commission
You were pursuing a B.Ed for special educators course.
Yes.
And you are
I
you
want
are a B.Ed qualified.
no, I'm pursuing.
By in say fourth paragraph it is said Oh, that is a mandatory
Eligibility-
criteria for participation in that recruitment.
In the recruitment, not the teachers' eligibility. Recruitment rule says first there will be teachers' eligibility test. Thereafter, the recruitment will be held. In the recruitment, the teachers' eligibility test will be having some marks, which is the only written. I will be showing you.
Maybe, but the prescribed qualification was
For
this.
recruitment, not for teachers' eligibility test. For participating in the teachers' eligibility test,
How, if you are not suitable for recruitment, why they will allow you to?
that is the TATE guidelines. Kindly cease, and this has been considered by the Supreme Court. Supreme Court has held.
Then why didn't you come in time? You had been a fence sitter.
Well, only kindly cease. What is the
9th September was the date.
The recruitment process itself is contrary to the order of the Supreme Court, which gives me right to part. Kindly once comes to the TATE guidelines first, and thereafter page 94.
Those points were not taken.
Well,
now you have been engaged, you are not taken.
No, I was there, man. I had.
Then
Kindly
where have
comes
you
to page
taken?
20. It is annexed, page 94. This is the TATE guideline. Page 9. This has been considered by the Supreme Court. Kindly comes. And this is also reflecting in the recruitment rules too. This is the guidelines for TATE, page 94. Guidelines for conducting this 2011 February 2011 guidelines for conducting teachers eligibility test under the right to such and such. Kindly comes to the next page.
Why? What is the wrong with this page?
Yes, that is the first page.
That
Next
point
page.
has not been discussed.
Eligibility.
Only একটা কথা বলেছি।
Following candidates shall be eligible to appear in the TET. Number one is a person who has acquired academic and professional qualification.
Why did you show us 94?
94 is the first page. Second page is the guide.
What does 94 say?
Is the forwarding of the guidelines. In accordance with the provisions of subsection 1, section 23 of the RT Act, National Council for Teachers Education had by notification dated 23rd August 2010 laid down the minimum qualification for a person to be eligible for
appointment.
Yes. As a teacher in class 1 to 8, it had been inter alia provided that one of the essential qualifications for a person to be eligible for appointment as teacher in any of the schools referred to in clause N to section such and such is that he/she should pass teachers eligibility test, which will be conducted by the appropriate government in accordance with the guidelines framed by NCTE. This has regard, please such and such find the enclosed guidelines for conducting the teachers eligibility test for the necessary action at your end. Now kindly see, next page is the guideline who are eligible to participate in the teachers eligibility test. Now, I'll just keep the background and everything, page 95. Kindly see eligibility. 5, clause 5. Following persons shall be eligible for appearing in the TATE. A person who has acquired the academic and qualifications, professional qualifications specified in NCT guidelines such and such, I do not fall in this category. I fall in category 2. A who is pursuing any of the teachers education course recognized by the NCT or RCI, in my case RCI, as the case may be, specified in NCT notification dated such and such. Now, my lord, this was considered by the Honorable Supreme Court. Kindly takes up, my lord.
No, Supreme Court will come later. Then what happened?
Thereafter, my lord,
there
was a litigation in the Honorable Supreme Court which says that.
Where is the notification?
Yes. The notification is at page 103.
No, this is August.
May I draw your lordship's attention to the rules and thereafter notification or directly to the notification?
Notification.
Show us the notification.
103.
No, it refers 9th September 25. This
Yes,
is August
104.
20.
104. 103 is the first page, 104. 9th September 2020.
Yes, show us what is the.
Yes. Teachers eligibility test 2025 and the first SLST for such and such. In compliance with the Solemn order dated such and such.
That order which you are showing us?
No. This is Rajneesh Pandey. In this order, the Honorable Supreme Court directed that in view of the dearth of the special educators, all the states have to conduct recruitment so that special educators are recruited in the school. Special educators are persons who are having special knowledge to teach, my lord, children with, my lord, disabilities, autism.
Now show us the relevant portion.
Yes, yes. Notification is being issued for conducting TATE 2025, second paragraph, page 104. And this notification is being issued for conducting TATE 2025 and the first state level selection test for selection to the post of special education teachers for upper primary, secondary and higher secondary levels in the government aided and sponsored school in West Bengal against the aforesaid vacancies, directing to be filled up by initiating fresh recruitment process, and further vacancies may be received from the West Bengal Board of Secondary Education under the West Bengal School Service Commission. Recruitment of persons for appointment to post of special education teacher, rules 24. Recruitment process will be governed by the rules and relevant guidelines of the state government. Now kindly comes to the next page.
Minimum.
4, written examination. This is state.
What is 2? Eligible candidate with the minimum
qualification laid down in 2024 rules may apply. This minimum qualification is the qualification for recruitment, not.
Show us that rule 4.
Rules. Yes, yes. Kindly comes to the rules. They have set out in the advertisement itself, but also
set out. Where is it?
Page 109.
কেন এসিটা চালিয়ে রাখছে বলো তো আজকে? So your contention is the persons pursuing has been omitted, though the NCT regulation said that they are eligible to participate.
And their rules also say.
Rules
of this recruitment. Kindly comes to the rules, page 114.
Yes.
This is the rules. Kindly comes to page 116.
Yes.
Rule 11. Conduct of teachers eligibility test and selection of candidates and preparation of panel of special educators in such and such. West Bengal Central School Council for arrange such and such. Kindly comes to 3 clause. The West Bengal Central School Service Commission shall conduct TATE for special education teachers following NCT norms. MCT norms, clause 5.3. Clause C, my lord. Page 106. Why? 116. Yes. 116.
Yes. 11.
11 is conducting of TATE. How the TATE has to be conducted? Clause 3.
For special education teachers.
Yes. 1, 2 kindly is not relevant. 3. The West Bengal Central School Service Commission shall conduct TATE for special education teachers following NCTE norms. And norms entitle us to participate. Now kindly comes to the last clause in that. May I just place the entirety? For the purpose of
entirety not required.
So the entire thing is now kindly comes to clause 9. The West Bengal School Service Commission shall publish the result of TATE and issue certificate to the TATE qualified candidates following NCT norms. Now thereafter kindly comes to page 117. Next page. Clause 10. Thereafter, selection of the special education teacher shall be made on the basis of the aggregate marks obtained following components. First is weightage of TATE, 80 marks. Thereafter, demonstration of room, teaching, interview, such and such. That is 10 plus 10, 20. So they have to conduct a TATE first. In that TATE, they are restricting me to, my lord, participate, although the NCT norms grants me an opportunity to participate. And may I just rely upon the judgment where, my lord, the Supreme Court has, my lord, held this in my favor, and subsequently it has also been, my lord. This is the judgment, my lord.
So when you will be completing your course?
My lord, I am first year, it's 1 year.
How
If I
many?
if I do not complete,
How many years course is it?
2 years. 2 years.
When did you get admission?
1 year back. I have annexed the documents. I am in the first year. This is like, my lord, completing law. If I do not, my TATE qualification will be there. I will not be required to participate in the TATE on subsequent occasions.
To appear in the TATE or not, that is another aspect of it. So whether they should have approached the court.
I've completed first year.
On conclusion of the examination, that is another aspect of it.
Filed, my lord. Just at the my lord, after the vacation. Just after the vacation. Just
4th
reopening.
November 2025.
No.
As recorded
Yes,
in
1st
the
October.
Supreme Court.
31st October is the, my lord,
31st October you
affirmation. Next 4th October is the filing.
4th November 2025.
Yes.
Whereas last date for filing application expired on
24th
24th September 2000.
Just before the vacation. But I am challenging the notification.
Now,
That notification should be, my lord,
now when is the TATE going to be held?
not declared. That is my not declared. Not declared. Because they are busy with
has
the.
not been held as yet.
No,
Hmm.
it has not been declared. Because they are busy with that other recruitment 9, 10, 11, 12, Group D, Group C, which is being held pursuant to orders of Supreme Court. So they are busy now. With now, my lord, kindly sees
What is
the
the Supreme Court order?
that is
that
yes.
is-
Kindly sees this, my lord.
Para.
Paragraph 7.1. The issue, may I just place it? 7.1, 7. The issue involved in the Lordship is there.
Yes.
Issue involved in the present appeal is the meaning and the interpretation of the word quote unquote pursuing as appearing in clause 5.2 of the NCT guideline. The question for consideration is eligibility criteria to appear in the TATE examination. It is apparent from the reading of the guidelines framed by NCT paragraph 5 that the incumbents who have acquired the qualification as well as professional can apply for TATE examination. The second category of candidates who can apply for TET examination is those who are pursuing any teachers training course. The meaning of pursuing is a person who is undergoing any of the teachers training course. He must have the he must be admitted and pursuing the teachers training course which is prescribed as qualification. Declaration of the result appearing in the examination or the date of filling up the forms, etc., cannot be the criteria to appear in the TET examination. Therefore, a candidate who is undergoing, that is pursuing the requisite teachers training course, shall be eligible to appear in the TET examination. Thereafter,
Right, Mr. Light.
yes,
we understand your here. But here the issue is not that. Issue is you could have blamed them had they not accepted your application if you have cut off within the cutoff date.
that was right.
There are two issues, Mr. Lai. Court said that as regards your, we find prima facie substance in what you are saying. But what did the single judge decide?
You have missed the bus.
Question does, yeah, missed the bus. Now, how can we pass any interim order in this? Court has rightly
I
said.
am saying so because.
And what was your prayer in the writ petition?
Participation and modification. First prayer, page 42.
Page 42, where this
See. Prayer A was leave
to allow the petitioner to fill up.
It was there.
That time is by the time your prayer has become infructuous.
Then E, my lord, prayer is also there. I am seeking for modification.
So you
because at
had
the
a
first
good
instance,
case. You did.
what happens, my lord? Only the commission, my lord, only to my lord, lower their work pressure.
Don't blame the commission. First of all, you failed.
My lord, it was not possible for us to, my lord.
Why not?
My lord,
Your clients are aware of this.
my lord,
Once he would have gone to before the online submission, if you would have said that I am pursuing, you now do not accept. And
there
we
was
are
no,
going to court.
there was no, my lord, opportunity given to us
How
to
can
fill up.
we-
We
how-
could not have fill up because the CRR number is required.
Mr. Laidi, how can we set the clock back now?
As of today also, my lord,
How we will direct them that you fresh application you receive and conduct. Is it possible?
my lord, take our offline applications. Lordship has, my lord, directed on the last occasion also. I have, my lord, seen, Lordship, I have handed over the order.
That we passed. That
1 or
means
2 days. I understand.
those who have not filed the writ petition within that date. So
Yes.
we asked him that cannot be a rider for.
Only for, my lord, kindly appreciates, my lord. First of all, we are not supposed to come. How many people know that if you go to the High Court, then something will be happening? Financial strings are also there. SSC candidate.
তাহলে কোথায় অ্যাপ্লাই করছিস
SSC
তে অ্যাপ্লাই করছিস
তুমি বলবি ওই তো আসলে আমি
কিন্তু ওদের কাছ থেকে
মিনিমাম কোয়ালিফিকেশন বিএড ইন্সপেক্টর
চাইনি চাইনি এটা ভুল আছে আর ওদের ওই
and RTI CRR number, that is like our enrollment number. Until I, my lord, get, my lord, the law degree, I will not get the
এখন কোয়েশ্চেন হচ্ছে তুমি ওদের জন্য ফ্রেশ টেস্ট কন্ডাক্ট করো
Firstly, the order which my learned friend has handed up, that 11th November, passed by your lordships.
No, we have not seen that.
Yesterday I have
Yes.
handed over
That-
saying that order was against me, but
Yes.
since he will be.
This closes the entire chapter.
Yes.
Your lordships have specifically held that if they have approached the commission or the court within time, only those candidates will be allowed. Kindly see the last page, the second page, the second last paragraph.
File করেছিল it would not be taken up. সেই জন্য আমরা would be taking time and realize only to the dinner participate pursuant to the scenes Dr. Matsu. Something এটা তো ওই ন্যারো ক্যাম্পাস কম্পাস
আগে এসেছিল কিন্তু
did you challenge the notification?
Yes, here. Prairie.
Yes.
Recorded by the Honorable Trial Judge also.
Yes.
Seeking modification of
সেশনে চলে গেছে আমরা বললাম নিয়ে নাও
কোন প্লেয়ারে করেছিস
আগে এসেছিল সেপ্টেম্বর
এটা তো সার্টিয়ারি
পিটিশন
modification.
পিটিশনটা পাই
ये तो করেছে
Suitable modification allowing the petitioner and the other similar page 40 তো খুলেছেন তো এই যে suitable modification allowing the petitioner জানেন
Dr. Pastro, your notification, you have not invited any application from the pursuing candidate.
No.
Although admittedly in the rule as well as in the decision of the Honorable Supreme Court, the pursuing candidate is eligible to appear.
No, kindly let me.
Because this judgment was passed in 2021.
Yes, because of the 2021 judgment, this is happening. Today's recruitment.
Then this
But yes, this is the thing. Kindly visualize two different examinations are being held. Teacher eligibility test, that is TET, and the selection test. Two different rules. Two different rules for two different selection processes. Now the degree.
Eligibility is the same.
No, it is not.
Eligibility for TET is different from eligibility for appointment.
Yes.
How?
I'm coming to that. Let me explain. Let me
Your
go.
rule says that it should be RCI approved. Especially.
Yes, I'm coming. Let me come step by step. Let me first clear the background, then I will come to the rule. So two separate examinations. For one examination, a pursuing candidate of B.Ed special education can apply. That is teacher eligibility test. But for a recruitment process to apply, you are to have the B.Ed in special education.
Yes.
So if you do not have the B.Ed in special education at the time of making the online application for the recruitment process, then your degree will not be accepted. Two separate selection process, one selection process.
How he will show you the degree if you don't allow him TET? Today he is in the first year, prior to holding of the second phase of scrutiny. He will get if he doesn't get that certificate.
No, that is not the rule. I will come to it. That is not the rule. Two separate examinations.
Yes, that is all
teacher
right.
eligibility test, recruitment test. Teacher eligibility test allows a pursuing candidate to participate.
Where is that? Where is your notification saying pursuing candidates can appear in TET?
Can appear in TET. That is the NCT rule. That is the NCT rule.
No,
nobody is disputing it.
119.
Where your notification you mentioned and you invited application from them.
109.
No, we did not. Let me explain. Let me explain. Then we will come to the rules. What have we done? How has the court rectified us? This is very important. And now what is the position? Then the rules and everything. So we have two examinations. One examination, that is the teacher eligibility test, is one of the factors which is to be considered in the recruitment. A candidate pursuing the B.Ed in special education can pursue TET simultaneously. But to participate in the recruitment test,
Yes.
you are to have the degree
Right.
on the date of making your online application.
Where is
That
your...
is the rule. Now I will show the rule. Then I will go back to the background. Kindly see page 116. Page 116, Rule 10. This is the recruitment rule. This is not the teacher eligibility test rule. This is the recruitment rule. Kindly see Rule 10, submission of applications. May I read it? The proviso is vital, but I'll read the full. The application shall be submitted within such time and in such manner as may be specified by the West Bengal Central School Service Commission in the advertisement. Those dates your lordships have already got. And or in the public notice issued time to time, provided, this is the important part, that the qualification attained up to the last date of application as per recruitment notification and also mentioned in the application form shall only be counted for academic and professional qualification. So he made his online application to participate in the recruitment process. He could not make it. The last date was 24th of September.
So
he does not have the B.Ed degree on that date.
No. The qualification attained up to the last date of application. That is the last date 9th or something like
24th
24th. That's it.
September.
As per the recruitment notification.
Yes, this is the recruitment notification.
Kindly
qualification
let us read now.
Yes.
Qualification attained up to the last date of application.
And mentioned in the form.
Also mentioned in the shall only be counted.
So he does not have the degree for the recruitment part.
No, shall only be counted for academic and professional qualification.
Yes, eligibility. That is the eligibility.
Our question to you is, when a pursuing candidate has a right to participate in TET, how can you deny the right?
Because TET is not part of the recruitment process.
No, you're opening the gate.
No, we did not. We did not. That is why I said how the court has rectified us. That is also important.
Which court has rectified?
The single bench, the learned single judge has said that no, you are wrong. Let me come to it step by step. Now kindly see the advertisement.
One thing.
Yes.
If the recruitment process is divided into two parts, one
TET is not part of the recruitment process, subject to correction by your lordship.
Selection process and recruitment.
Selection process and TET.
It is not. TET is totally separate.
Separate.
Totally separate.
Now, one person who is, when you are holding the examination TET, then the two candidates will be eligible to appear.
Yes.
That means
those who have
and
those who are pursuing. Yes.
TET. But if you simultaneously hold the selection process, who have not passed, he will not be able to appear in the final selection process.
No.
But he will appear in the TET, but he will be ineligible to appear in the final selection process. He is to wait till completion of his.
Without completing his educational credentials, the eligibility criteria, he cannot expect to participate in the selection process. So that was the filling up of forms.
So you are excluding pursuing candidates from both the selection as well as from the...
Yes. Why also I will explain to the court.
Yes, explain to us.
Now kindly come to the advertisement.
How you work, Dr. Patro, your commission facing thousands and thousands of litigation, still you people are not concerned.
My lord, we are concerned. That is why we are opposing so strongly. Kindly allow me.
You can do.
Kindly allow me.
Had you there been in the commission, the legal advice which is being given, this ought to have been sought from earlier to the selection process.
Then the recruitment we will have to postpone it for
Yes, if done so, you have to postpone. You are under the law, not above the law.
No, we are not. We have not
But
gone
you are
above
not
the law.
careful. Anyway, so
My lord.
you people commit all sort of problems and you then blame others. Why didn't you come within that date?
No, no, we are not doing that. We had
Yes,
expected
yes,
them.
yes.
We did not say, why haven't you come? We
Where
have
is your
said that
notice?
you are out.
Actually, let us see.
Okay, let us see.
Now
where.
kindly see the advertisement, that is page 104, the heading, Teacher Eligibility Test 2025 and First SLST 2025 for recruitment of special educators in government aided, etc. schools. So two parts, the teacher eligibility test and the selection test, the recruitment.
Now kindly come to page 109.
Now, let me first kindly allow me to complete what I was trying to get at.
Yes.
What the commission was doing is, commission has to hold the recruitment test. That is our responsibility. Now, to appear in the examination, TET is one of the vital requirements. So candidates who did not have TET but had the qualification, that is the B.Ed, the training qualification, they were allowed to fill up the forms.
Yes.
That was our stand. Your lordships rectified us.
That is how you are saying.
When we first faced the cases before the learned single judge, the court said no, they are not eligible to participate in the recruitment test. Very well, but why will you not allow them to take the TET examination? We had submitted that since we are a recruiting agency, we will only take the TET for those who will participate in the recruitment, not those who are not eligible, meaning not having the training qualification.
So
Court-
that is that not contrary to the NCT guideline?
No, because taking TET examination here, this TET examination was not meant to be a blanket examination for all eligible candidates. It was an examination in connection with the recruitment, that I'm recruiting only eligible candidates who will suffer for not having the TET. Only their examination I will take, meaning those who have the B.Ed. This was our stand, and that is how we were proceeding. When the court heard the matter, the learned single judge heard the matter, 2 or 3 matters, the court said, no, you should take the TET for the candidate who is pursuing the examination on the condition they will give the undertaking that they will not participate in the recruitment. And also taking into consideration that they have approached within time.
Right.
These were the 2 conditions. The court passed the order, we accepted. 4 or 5 candidates were allowed. One candidate, the order which my learned friend has handed up, he came 1 day later. Your lordships held
That as the writ petition could not be taken up, he should.
it was filed within time. And your lordships even added that if there is a representation also, a communication to the commission within time, then that should also be, then also it should be allowed. So those candidates who came within September, 24th of September, who gave the undertaking that they will not pursue the recruitment, they only want the TET, only those candidates were allowed, and your lordships have upheld that order. So the undertaking part also is
We
there.
set aside the order and said that you will do it now.
Yes.
That was the order.
Yes, yes,
you, are,
yes, yes.
you took information and then said that these are the problems.
Yes.
Our question is not that, Dr. Patru. That is one aspect you have in your hand, that you did not come within 24th September, lock, stock, barrel, you go.
And no, in addition to that, only those were allowed who have
Undertaken.
said that we are not interested in the recruitment.
Very good.
Because I am not eligible for recruitment.
Yes, yes, no.
SLST. They will not appear in the SLST.
Yes, deeply obliged.
But here we are not on that. We are saying that first, you are right, first phase is TET.
Yes.
Second phase is recruitment, where TET will be a criteria for consideration. 2-phased selection process. Now, if you are today closing, forget about that point that he did not come. Suppose today you are saying as per the rules that only B.Ed qualified, those special educator who has obtained the qualification approved by RCI, they can apply for participation in TET. This decision of yours that you will only allow TET special educator qualified candidate having the degree to enter into TET, because your explanation is that that is the ultimate qualification which is to be satisfied by a candidate at the time of recruitment. Now think about one thing. Today, suppose I am an RCI approved institution special educator in my final year. When you are asking me to deposit the form, I am not obtained the degree, so automatically you will say I am barred. But my argument is that I will obtain the degree after the TET qualification, after the TET examination is over. Then I would become entitled to this recruitment process, but I will be prejudiced since I have not been allowed to in the TET, where TET is a mandatory qualification.
Yes, because you did not have the qualification. That I read out the proviso.
Problem is that you are holding the two tests simultaneously.
Lordship.
And hence you are creating problem.
No, we are not. We have opened the gates for eligible candidates, not for the ineligible candidates. TET is not actually part of our responsibility. The Act provides that we conduct the recruitment. TET is to be held by the education department. They give us the response.
No, Mr.
It is your notification.
Yes, because the state has given us the direction to conduct it. Every time they give it to us, we have never managed to escape it.
You come to page 104.
104.
Yes,
I'm on
notification has been issued for holding a teacher eligibility test 2025 and the first SLST.
Yes, we have separated the two.
2005.
With the and.
But simultaneously. Now, teacher eligibility, don't forget about the first SLST 2025. Teacher eligibility test, two candidates who have already passed B.Ed and who are pursuing B.Ed are eligible to appear. Now, you didn't invite who are pursuing candidates.
No, because they are not eligible for the recruitment part. So, unnecessarily taking their TET would.
But had it been done separately, whether the pursuing candidate.
Then your lordships will visualize. If I do it separately, then maybe one candidate has just taken admission in the current session. So my selection process will wait for 2 years just because one candidate has taken his admission in the 11th hour. That cannot also be.
No.
Whenever an opportunity comes, a candidate is to be ready.
No, you have to say that that undertaking you sought for. That since you are appearing in this, that does not mean that we will automatically allow you.
No, they will not be allowed.
They will not be allowed.
Yes.
Unless they have the degree prior to the date of the qualification which will be demanded.
Yes. But my learned friend is wanting both, number one. Number two is that now that the last date has gone, they came much later. There was a vacation, yes, for the advocates, but the commission was open. One letter anybody could have written and dropped. Commission does not enjoy 1 month's puja vacation.
Yes, challenging the notification. What will be the answer?
There is no challenge. That is my answer. In the prayer of certiorari, he has added one line. Where is the actual prayer? There is no real prayer. Kindly see.
Finally.
Your lordships know what my answer is. Two more aspects. This order we have constantly been cited before the single bench. Though the single bench was previously from having the same view, but your lordship's division bench order we are using as a. And number two is my learned friend is saying that we have not done anything, but this entire 2 months or 3 months, whatever has passed in the meantime, we are processing all these applications. A few lakh before announcing the schedule, we have to process. That processing is also ongoing.
We understand because we are concerned about this fact today. If this is done, this will open open a floodgate.
Floodgate.
That is why
Thousands of
lordships
candidates.
rejected on.
No, this point was not argued. Now the situation has come whether we have to weigh whether his right prima facie which we find can be washed away for non-approaching the court, more so when you also did not seek application for participation in TET from candidates pursuing the course.
Pursuing the course.
So these two things have to be weighed. This is another problem.
Otherwise, after 5 years, this will be shown as a vitiating factor. There will be some litigation somewhere, and this will be shown as a vitiating factor.
No, your lordship.
Take advantage of it.
I will not be there.
You have come late. Now you are trying to justify your conduct. Say, I have a point in law. Equity will prevail. You will make these arguments.
I might not be there.
Dr. Patro, give a thought to it. If we pass an order to that effect, commission will be in problem.
Yes.
So whether you restrict yourself by taking them or not, if you allow them,
if we allow, the floodgate will open, all the pursuing candidates will come.
all the pursuing candidates will now come to the High Court and say this, or you have to go to Supreme Court to test our order. Now again the complications arise.
Yes, yes.
First was 26,000, next was 32,000. Now next what appears will not.
Next was, my lord, it is ease.
হবে বলো?
20.
কটা vacancy দিয়েছি আমরা?
How many persons
না,
are here?
এটাতে কথা বলি।
How many
How
persons?
many percent?
8.
80.
8, only 8.
Only 8.
We will say he will withdraw the writ petition as you are allowing them to participate in TET upon accepting offline application. He will not proceed with the application. We will not decide this point also. Finished. And if Dr. Patro, then we have to deal with your argument. No, we have to pass an order.
Let me take some instruction.
Instruction যদি দিতে পারো ভালো, we will say petition dismissed as withdrawn. Gone everything.
We have to punish them.
Shall we go and
Not
meet him or
court before the last?
টাকা দেবে? Cost impose করে থাকো।
ম্যাটারটা কোনটা? 9.
Item number 11. 11 also commission.
Yes, this is
Oh, that 17.3.
yes. After রুলটা এটাও তো নিতে পারতো সাইড থেকে উঠে
Now, Mr. Shimu, what did you submit as regards change of rule?
Change of rule, I could not find any whether amendment or not superseding. But 2018 rule, the appointing authority already changed. The president of the board is the appointing authority instead of the managing committee. And that rule has not yet been changed by the School Service Commission. On the other hand, they have acted upon. Not only that, each and every year they have issued series of appointment, and that point they have not raised at the time of passing the region order. And after lapse of 7 years, they have come and raising this.
How that could have helped you, Mr. Shimu?
Pardon, my lord?
How that could have helped you?
My lord, they have already acted upon
Your grievance is that those two vacancies were not notified to you.
Yes.
At the time of council.
Yes, my lord.
So, and their case is that you were recommended, you did not join, so you automatically depanel. And second is that it was an impossibility on the part of the commission to know at the time of fourth counseling whether the vacancies have been filled up or whether the persons have refused to join the post or whatever. But that period, how the procedure is that 90 days and 16.5.
Yes.
That first it will be valid for 90 days, then it will be valid for 60 days more. So 90 and 60 means 150.
Yes.
150 days. Now 150 days had not expired on the date you were called for.
Yes, my lord. According to circular rule 2016. But in my case, rule 2018 applicable.
2016 rule.
Yes.
But that was not your case in the writ petition.
No, my case is the appointing authority is the president of the board. As per rule 2018.
Where is that annexed? Page?
No, my lord, I have already handed over. Government
yes,
of West Bengal School Education Department,
yes.
secondary branch. Rule 3, my lord, kindly see for a moment. Hours and duty of the board to appoint headmaster or headmistress and assistant teacher and non-teaching staff. Therefore, my lord.
So this is the appointment, confirmation, conduct and discipline of teachers and non-teaching staff.
Yes. Then in terms of the rule.
Now, this will occur.
Yes.
Now, this notification was 18th March 2018.
2018.
So your argument is that selection committee, the school managing committee is not even the appointing authority.
Yes.
So the appointment which was given to you had no value. It ought to have been given by the appropriate authority, being the board president.
Yes.
Then how that helps you?
Where is that rule 9 annex?
Is it
rule 3?
Oh, you read on that date you read this commission shall be informed within 6 weeks from the date of
yes,
this recommendation of the action taken by the such and such. You read last line, then the next line. This recommendation for appointment of headmaster in secondary school is pursuant to the rule 9 of West Bengal School Service Commission Act 1997. That means this rule.
Then kindly see page 43. The condition imposed in the appointment letter. You are requested to join the school within 15 days. Page my lord 43.
15 days, but recommendation you are seeking applicability of this rule.
Yes.
This rule,
yes,
maybe, but it was specified
on the basis of this rule, the board issue appointment letter.
That the recommendation for appointment to the board is pursuant to the rule 9 of the West Bengal Commission Act. It has been pulled because rule 16 rule. It could be 16 rule. 9, 16 rule or Which Rule 9 of any act?
Rule 9 of the
1997.
What's the Rule 9?
Page 41.
It's Rule 9 of
Rule 9 হচ্ছে advertisement, page 62.
কিন্তু কোনটা বলতে চাইছে এটা সেইটা নয় তো
Its recommendation for appointment in pursuant to this rule 9 of the rule 9 এ advertised হয়েছে vacancy হচ্ছে সেটার কানেকশন
pursuant to the আচ্ছা
ওর বক্তব্য in your case appointment letter was issued by the school.
No, by the board.
His appointment?
Yes.
Board.
Page.
Page
41. No. 43.
43.
Yes.
43 ঠিক আছে
Oh, so your contention is that now how does this help you, Mr. Shimui?
43 টা আপনার না
43 is yours, Sushanto Ranjan Sahu. No.
48 is my learned friend's client.
Yes.
So your appointment letter has been issued by the competent authority.
That means board president of the board.
Now thereafter you went to join the school.
Malu, kindly see the condition imposed. You are requested to join the school within 15 days.
Page 48.
48.
Yes, 15 days. So you did not join it. You did not
But
join.
my lord, the council is kindly see, my lord, my grievance, my only demand a non-joining post, which was not uploaded at the time of counseling.
But how can it be uploaded?
How can on that
But my lord, condition is imposed with the entire process should be completed within a period of 6 weeks. That means the first week of January, entire process should be completed. My counseling was started on and from 17th January 2020. Prior that vacancy was lying.
On that date a question was
17 January?
The counseling was started.
17 January
2020.
20. Yes. So what is your argument?
First
Counseling?
week of January, vacancy was lying, non-joining post.
That is you are saying on the basis of which letter? Non-joining?
That is page 43, non-joining post, appointment letter.
Very good.
Yes.
So
But
this letter of appointment, can it override the provision of Rule 60?
No, my lord, that appointment letter was issued 10th December 2019. Within 15 days must be joined.
Very good. He did not join.
On
Need not join.
Yes, on that the and a duty was also imposed upon the board to inform the commission that such recommended teacher has not joined. But the question is whether if such information is not given, then whether commission
my lord.
shall have
No, my lord, information not
authority to-
no. My lord, information not required
How
to be given.
commission will-
My lord, automatic uploaded in the portal. Kindly see their region order.
was submitted.
Yes, yes.
Because I don't know what your lordships are going to direct. The noting in the board's letter, that is page 40, 48.
Yes.
That to join within 50 days, 15 days. This is just a direction. It is not supported by any rule. What the rule supports is that the recommendation is valid for 90 days. And that took us beyond the lifetime of the panel. And admittedly, from the letters annexed to the writ petition, it is clear that the communications were all made after 17th of January. So we could have not known about the vacancies at the time of the counseling of the petitions.
No, 17th was the counseling.
Yes.
So
Panel had expired on 15th. This was the last counseling which was being held 2 days after the expiry of the panel.
this was the last date of council.
Yes, this was the last date of council.
So this letter was issued on 28th January. Commission asks the person to join within 15 days.
Yes, that means
This is
my
one such vacancy.
Yes.
This is one such vacancy.
This is my learned friend's letter.
Yes, yes.
But what I'm pointing out from the letter is this 15 days is just a direction of the board upon the candidate to don't waste time, go and join. It is not supported by the rules. It is not part of the rule. Rule does not say anything with how many days you are to join the appointed post. What the rule says is that the recommendation letter is to be kept alive for 90 days. Plus 60, I'm not going into the 60 part because that requires a decision of the commission. 90 days on the date the letter is issued. Now just kindly, your lordships, come to the two schools where the candidate wants to go. Those appointment letters. One is at page 40.
No, just now you showed page 48.
Yes.
Page 48 you showed that 15 days is just a time. Yes. No, his argument that board issued him appointment letter on where is that page, Mr.
43. 43, my lord.
43.
At the bottom of all appointment letters, that 15 days time is given by the board.
No, his argument is board is the appointing authority.
Yes.
So board asks the person to join within 15 days.
Yes.
It was incumbent upon the board then to immediately intimate the commission.
Because the joining will happen in the school. So the board is not aware of what is happening in the school until it filters back to the board or to the commission.
That is the laxity in the rules because you are taking advantage about the 90 days window which is given.
Yes.
But if you
That is
do
given
not
for the
ensure,
candidate, it is not given for ourselves. The candidate, if he is in
Yeah,
difficulty, if he
understand.
cannot
Yeah,
join within 15 days, he has 90 days in his hand plus a right to ask for an extra 60 days.
yes, which page you are now showing?
Now kindly see page 40. Sorry. This letter is from the first school.
Yes,
This letter is of the first school, page 40.
40, yes.
It is written to the district inspector of schools, which means it has not yet reached us. The date is 28th January.
Yes.
So we have not yet received the intimation of non-joining. It is also after expiry of the panel.
Okay, counseling. School inform.
But it is within the 90 days. It is within the 90 days.
No, 15 days.
I mean 90 days.
Oh.
The recommendation letter was issued on the very next page on 25/11/2019.
Where is the order impugned which was page 57? No?
Yes. The key point was not taken in the region order.
WP নাম্বারটা
একটা 7 পর্যন্ত হয়েছে। হ্যাঁ। এখন কন্টিনিউ ম্যাটারগুলো দেখে
আবার
দুদিকে লেখা আছে, দুদিকে লেখা আছে, একদিকে লেখা আছে।
Judgment, item number 1 to 44.
It's known as pinner of silence.
This is called a pin of silence.
Pin.
It is a real conundrum. Regard being had to the fact that we are dealing with a judgment dated 12th May, passed by the learned single judge in writ petition such and such, cancelling the appointment of 32,000 candidates who were untrained at the time of selection in the recruitment process conducted by the board. It was also inter alia directed that the board to immediately arrange for a recruitment exercise for the candidates who were untrained within a period of 3 months. Assailing the said order, it went up to the intra-court appeal, wherein an interim order was passed against which Supreme Court was approached. Supreme Court relegated the matter for fresh consideration of all the issues upon allowing the addition of party. The matter involves cancellation of appointment of 32,000 primary teachers who have rendered uninterrupted service till the date in different primary schools all over the state. It has been alleged inter alia that the board committed fraud and the recruitment process was not conducted as per the West Bengal primary teachers recruitment rules of 2016. Whether such circumstances would warrant a zero tolerance approach or as to whether it would be iniquitous to interfere with such appointments had compelled us to pause, ponder and confer anxious consideration upon the same, which would require untangling of a complicated mesh of competing rights. So we went on to record the submissions as have been advanced by the learned counsels appearing for the appellants. Mr. Dotto was there, Mr. Anindo Mitro, Mr. Joyanto Mitro, Mr. Kollan Mondobadhyay, then Mr. Obrotosh Mojumdar, and the other counsels. Pardon us if we have missed some dates, it is there. We have also recorded the contention of Mr. Ashok Banerjee, Mr. Saptang Subashu, Mr. Pratik Dhar, Mr. Parthasarathi Bhattacharya, Mr. Obrotosh Mojumdar, and other learned counsels we have appeared. It was opposed by the Mr. Kumar Torunjyoti Tiwari and Mr. Torunjyoti Tiwari, Mr. Bikash Ranjan Bhattacharya, Mr. Firdos Shamim, Mr. Sabir Ahmed, Mr. Other advocates were there. We have recorded their submissions and we have considered the same. So we have proceeded to deal with the matter, deal with the judgment which has been impugned in the present appeal. The findings of the learned single judge can be culled out from the impugned judgment are as follows. No aptitude test was held. There was no formal engagement letter for acting as an interviewer, nor any guideline for awarding marks for aptitude test. The marks given to the candidates against aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. There was a wholly absurd assessment in interview, and such assessment reveals extraneous factors, which includes corruption, as has been alleged by the petitioners and now has come to light from the investigation by CBI and ED. Non-empanelment of reserved category candidates in the panel for general category candidates who got better marks. No selection committee was constituted for the purpose of selection by the board. An outside agency was engaged, and the board and its officials, including the former president, conducted the whole affair as that of a club, and jobs were actually sold to candidates who had the money to purchase the employment, and that lastly, the recruitment scam, stinking rats are being smelt. We dealt with each and every finding of the learned single judge, and we went on to observe as follows. Upon dealing with the judgments on which reliance was placed before us, including the judgment delivered by a coordinate bench in the case of Boishaki Bhattacharya. So we ultimately concluded to this effect. It is true that courts should emphasize the need for fairness, transparency, accountability in public service, and shall support wholesale cancellation of examination if systemic irregularities undermine the process integrity. Systemic irregularities refer to widespread flaws, malpractices within a system, process, or organization. It includes cheating and impersonation, large-scale irregularities, including those which have the effect of denying the equal access to similarly circumstanced candidates, are suggestive of malice, eroding credibility of process. However, court is not expected to indulge in roving inquiry to rule out all possible explanations and alternative scenarios justifying such irregularities. There is a difference between a proven case of mass cheating in a board examination and unproven imputed charge of corruption. When services are terminated on the ground that the incumbent aided and abetted corruption, the court must satisfy itself that condition for this exists. The irregularities alleged in the writ petition were primarily pertaining to TET 2014, through which the candidates earned the eligibility to participate in the interview and aptitude test. While deciding the issue urged, the court went beyond the pleadings and cancelled the appointments made upon a purported finding that no aptitude test was held. In the dispensation of justice, courts are prevented from innovating at pleasure. Neither can they don the helmet of a knight errant roaming at will in pursuit of his own ideal of beauty or of goodness. At all times, courts are expected to draw inspiration from consecrated principles. A finding as regards widespread or systematic irregularities is absolutely indispensable for cancelling all the appointments made. For cancellation of the entire examination, there must be as a rule possibility of systemic malice as borne out by materials on record. Assessment of the data does not indicate systemic cheating. It also needs to be mentioned that during the period of service rendered by the appellants, there had been no allegation regarding the integrity or efficiency of those teachers. It is not a case that instructions were given to the examiners to give higher marks, or that the candidates who paid money had been given higher marks in the interview. A group of unsuccessful candidates should not be allowed to damage the entire system, and more so when it cannot be ruled out that innocent teachers would also suffer great ignominy and stigma. The service of the appointees cannot also be terminated only on the basis of an ongoing criminal proceeding. Reliance has been placed upon the charge sheet and supplementary charge sheets by the writ petitioners. In the same, the investigating agency observed categorically that appointment letters were issued upon receiving recommendation letters from the board. Findings arrived at by investigating authority would not reveal that the appointed candidates were involved in any corrupt practices. Upon investigation, it was ascertained by CBI that irregularities exist in respect of 264 candidates who were given grace marks and were identified. Additionally, 96 candidates also did secure qualifying marks were appointed and they were also identified. Subsequently, these 96 candidates were terminated, but they are still continuing service on the strength of order passed by the Honorable Supreme Court. In view of such identification, the allegation of fraud and corruption pertaining to the entire recruitment process is not sustainable. It is the impact of the action that would define the nature of the procedure that is to be adopted. The effect of any direction for re-examination at this stage would have a dissimilar impact upon the appointees. Any such direction for re-examination would fail to secure fair play in action. A job taken away after about 9 years of service would indisputably cause insurmountable inconvenience to the appellates, and their survival along with their family members would be at stake. In such circumstances, and considering the enormity of the impact, we are not inclined to uphold the cancellation of appointment of 32,000 teachers who have worked in the post for a long period. For the reasons as discussed, the judgment impugned is set aside and all the appeals and the connected applications are disposed of.
Grateful, Mala.
And we are praying for stay of operation.
Not we are opposing, Mala.
Lord, I am deeply obliged to Lords, deeply obliged.
After delivery of the judgment, Mr. Tiwari
May I pray one thing, my lord? Because of that, my lord, the last location, my lord will remember on last location, my lord, regarding some can, we indicate the writ petition number. I did not know whether that is incorporated in the judgment itself or not, because of
we
the.
have said we have allowed all the parties to intervene. We have recorded the names of the councils who are appearing before us in respect of the councils.
Yes, I agree.
We have checked out our records. There were more than 5,000 applicants.
Yes.
So we have said that it would be cumbrous to add each and every person.
I am not. I am not on that.
Listen what we have said. We have so said, but about some applications were allowed by 3 orders passed by coordinate benches.
Yes.
We have directed the department to incorporate the names of those candidates who have been implicated.
Yes.
And others we have intervened, we have heard, we have recorded the council.
No,
Upon hearing.
No, my lord, I am not on that, my lord. Because of that, my lord, some of the can whose writ petition is pending. In the instance of that, my lord, they by mentioning their writ petition, they says our writ petition is pending on the grounds
Yes,
of.
yes, we have discussed that.
Grateful, my lord. I am grateful.
We have discussed, we
Yes.
have said that writ petitions
Independently.
are pending. Independent.
Yes, my lord, that's
petitions are-
enough.
Independent writ petitions are pending and that will be decided as per their merits.
Grateful, grateful. That's
Mr. Tiwari,
Most deeply obliged, Lordship.
did we record Mr. Tiwari? This one. It will be avoid confusion. Okay, Mr. Tiwari, learned advocates appearing for some of the writ petitioners stroke respondents in MAT 873 of 2023 and some of the applicants in CAN 5 of 2023, CAN 9 of 2023, CAN 17 of 2024, CAN 19 of 2024 and CAN 35 of 2025. Praise for stay of operation of the judgment. Such prayer is considered and rejected.
Grateful, Your Lord.
But it will be up in the server
Copy
today.
of the judgment.
We are extremely
It
grateful.
won't be handed over. It won't be handed over. You will get it in the server.
yes, yes.
It will be up.
Grateful, Your Lordship.
Grateful, Lordship. Most deeply obliged.
Item number 16. I'm led by Mr. Mukherjee. Last occasion, Mr. Mukherjee started showing from the list of dates. Where from, my lord?
I'm for the state, my lord. It's a voluminous brief, my lord. We have received 3 days back, my lord. Some time is required for preparing.
But the matter had been there for
Matter,
quite some time.
the advocate who used to appear, he has been depaneled. That's why reallocate.
We have given this copy, my lord, on 17th November. My lord, the
Last week we have received, my lord.
by my lord on 14th November.
My lord, kindly some accommodation may be given, my lord. At least 1 week, my lord.
1 week, how can we give? I will be not be here. I will be in circuit. So
Then, my lord,
within 1
kindly
week,
fix it after vacation, my lord.
they are insisting now. How it becomes embarrassing for us now. We have given adjournment.
Are you in possession of the land? Or they have taken? You are in possession, you are seeking mutation of your name in the ELA record of rights. And they have refused on the plea that it is a land, 60 land.
Startling fact
Common
is,
language, 60 land.
yes, startling fact is, my lord, the government has acquired the property on behalf of the company after the date of vesting. How come on the date of vesting, if this particular land is not in use for the purpose of factory, how come that particular land comes under the purview of Section 63?
Okay, we shall apply our mind.
এই
today-
জানুয়ারি মাসে দেখো বলতে ডেট একটা দাও, একটা টাইমার ডেট করে দাও। There are no other parties, Mr. Dhar,
No,
but from the state.
only state.
Omitra.
Yes.
আসো একটু দিয়ে দাও না।
Number 12.
Yes, Mr. Wadi.
upper primary.
Sir, we delivered a judgment. Upper primary is
quite different fact. That
The issue involved is similar to Mr. Shimai's matter. That is why your lordship, Mr. Shimai, the previous matter which.
Oh, acha, acha.
So.
That is why we kept
not
it.
Yes.
same, but similar, but not same.
No, the legal proposition is similar, but factually it is absolutely different.
Judgment will be same, but it will not be similar.
Yes, but he did not join. 90 days over, recommendation, no extension, he did not join. My case is completely different.
No, but he is waiting for the non-joining to come back. That vacancy, that is what he is expecting. Maybe he has joined in his school, but he wants to be recommended in a vacancy.
He has joined.
Yes, he has joined. But
Mr. Buddy, you are.
My recommendation will be cancelled if I do not join.
So now apply for transfer, Mr. Buddy.
No, I have not joined.
join করিসনি এই যে
Both the petitioner did not join.
তাই বলছিস
Yes, ma'am. They did not join. Join করুন।
So then, Mr. Buddy, do you want to go through our judgment which we delivered today? Because you have heard it.
Yes, ma'am, I have heard it.
Tell it. Yes, tell us what is.
Even then, but if your lordship wants that I may go through the judgment and then I can submit my.
No, I am not the advocate.
My lord,
want us to be there or what?
No, let me go through the judgment, my lord, let it be on next day, my lord. I'll only one day, my lord. Let me go through the judgment today, my lord. Perhaps I will read from the server, my lord.
Today we don't know, but it will be there by day after tomorrow or Friday. You place the matter. Because it is neither similar nor same, so we can proceed.
Here, what the petitioner was impaled as whitelisted candidate. My lord, kindly take my lord file as supplementary evidence.
Please show us the judgment in Pune. That is 26th February. Yes,
26 February.
So we will go. In the other one, he was not in the wait list. In the morning one?
Yes, he was waitlisted candidate. Fourth phase counts. After first phase or any phase of counseling is a waitlisted candidate.
I see. Yes.
We want to show the rule once. I have annexed that. But page 1120 page 82. 17.5. May I place it, madam? If a candidate refused to accept either allotment of post during counseling, or the Central Commission gets information from any school or from the District Inspector of School Secondary Education, or otherwise, but this otherwise is very important, that a candidate recommended for appointment has not accepted the offer of appointment or joined the post within the stipulated period, or such a candidate refused to accept appointment, or on further scrutiny it appears that the candidate has misrepresented the facts, the Central Commission may do away with his name from the panel and will be deemed to have been depaneled and recommend the name of a candidate from the waiting list strictly within the validity period of the panel of waiting list. Kamalat, yeah, the rule.
When was your counseling?
Yes. Mal, kindly take my supplementary evidence. I prepared a chart to that effect, Malat. One supplementary evidence. Page 5 of the supplementary. Okay, got it, Malat? Malat, subject pure science OBC A male female category. Empanel candidate was there 427 and well listed candidate was there 224 candidates. Malat, first page counseling was held Malat on twice on 23rd October 2024 to 11th November 2024. 427 all empaneled candidates were called in the first phase of counseling. They opted, and whatever may happen, they will not get any second chance. In the second phase of counseling, they called 164 candidates from waiting list. The petitioners got chance in the third phase of counseling because only 53 left out candidates were there. No other candidates were there. We are the last candidates appeared for the counseling. 53 candidates. Now, as per rule, if the vacancy is not filled up in the first phase of counseling, they will include those vacancies. School Service Commission include those vacancies either in the second round or the third phase of counseling. Now, my case is in the third round of counseling, they did not include. School Service Commission says that it is their choice when they will include those vacancies, because they said it is specifically recorded in the order. When they will include those vacancies in any round of counseling during the subsistence of the panel. My specific case is we are the last candidate.
Panel was valid till?
Still panel is valid, according to Lordship's direction. Because
No. Panel has expired. But those who are still before the court, for them that expiry of panel will not affect them.
When did it expire?
Primary date ki chilo? 25th September. This is that selection process where your lordships had directed 14,052 to be appointed, and we are stuck with the remainder for which your lordships have allowed us to talk to the state for getting additional vacancies. That matter.
My case was that we are the last candidate. After us, there was no candidate. So for this particular subject, there will be no subsequent counseling. So when they utilize the vacancies, far from they utilize the vacancies, if no other candidates is available, that was my case.
That will go to the next selection process.
Now that is not the process, but the rule specific says that they will, yes, Malak, they will include those vacancies in the next round of counseling. Malak, can you slot 17.5?
It starts with when the commission gets information.
Yes, Malak, they also got the information, Malak, that I have annexed those documents, Malak. Documents. The supplementary affidavit, Malak. Can you see? Malak, page 7, Malak. This is the recommended letter of a candidate. He did not join. And the school authority directly written to the chairman of the School Service Commission on 13th of January 2025. Page 8, can you see? Non-joining report.
Page?
Page 7 and 8 of the supplementary report. 7 is the recommendation letter of that candidate. He did not join.
Where is DIs to the chairman on 13 January?
Yes, 13 January 2025. School.
And your
and the next page is another candidate. Can you see? Next page is page 9. Another recommendation letter. And the school authority intimated the petitioner. Petitioner wrote a letter to the concerned school whether that candidate join or not. The school authority intimated the petitioner that he did not join, and the school authority intimated the same fact to the School Service Commission.
Very good. So, in view of the 60 days period of validity of recommendation, after they have to wait for 60 days.
60 days already.
90 days.
No, 90 days. Your
the last word you are omitting within the stipulated period.
90 days is not automatic.
Oh.
Candidate have to apply for ask for the authority to extend after prayer of the extension. They never approach.
Not prayer for extension. Recommend.
The recommendation was never extended.
Has not joined the post within the stipulated period.
Yes, stipulated period was 15 days.
You come to clause 5B.
5, Manoj?
5B. What you are reading?
15.
The Central Commission get information from any school or from DI of school or otherwise that a candidate recommended for the appointment has not accepted the offer of appointment. One, or join the post within the stipulated time.
Yes.
Period.
Kindly see
So
the
period which has been stipulated in the rule. Let us see.
90 days.
But they even did not collect the appointment letter. This is merely a recommendation. They even did not collect the appointment letter from the board.
No, we are trying to say once a recommendation is issued, there is no compulsion upon the commission to fill up the said vacancy prior to 90 days, because 90 days is the period for which the recommendation subsists. Now, your case is within 90 days, on January 2025, the school said that
recommendation letter validity is 90 days.
Right.
But after the recommendation letter, board will issue an appointment letter.
Yes.
That appointment letter validity is only for 15 days.
That is a general directive.
Yes, my lord.
That there is no rule that 15 days he does not join, that will curtail the period of 90 days as provided under 17.5.
Because nobody approached that kindly extend the period.
You are talking about subsistence of a legal right. You have a legal right to be considered against a vacancy which is put up in counseling. Your contention is commission knew that and it was an obligation on the part of the commission to show that vacancy.
Yes,
but this obligation is not supported by the provisions of the statute, because obligation is, suppose he has not joined, whatever the reason we do not know, I have to at least wait for 90 days.
No, Malad, that's not the provision. Malad,
Yes, kindly.
I'm saying playing
prior this period 17.3 shall remain valid. Suppose today, if the commission puts it up, got that clause?
That is in respect of recommendation letter.
One question we are putting. I have been recommended, say on 3rd of December 2025. I did not join within 90 days. Whatever may be the reason, the school was not choice, I did not join. School issued a letter prior to 19 days to the commission saying that, see, your recommended candidate has not joined. There is no statutory obligation or compulsion upon the commission that you have to immediately put it in the server or display it, because as per the statute, commission has to wait for 90 days. Otherwise, if an appointment is made, that person can come and say, my recommendation was valid and due to my father's ailment, I could not join. I would have made a representation. We are talking about a statutory obligation. You must be having a legal right corresponding, they have a legal obligation. This compulsion upon the commission, Mr. Bari, is not there. Read that fact with the fact that you accepted that post, you appointed, you got the appointment, you're serving in this school.
May I read 17.5 once again?
Yes, 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 yes.
If a candidate refuses to accept his or allotment of post during counseling, Central Commission gets information from any school or from the district inspector of schools or otherwise that a candidate recommended for appointment has not accepted the offer of appointment or joined the post within the stipulated period. That is 15 days.
No, no. That 15 days appointment letter issued by the board, 15 days his provision is nowhere there. Show us that you have to join.
In the appointment letter, they have stated they have to join
Appointment
within 15
letter
days.
can be said. Recommendation letter also says join, contact the school within 7 days and join immediately within 15 days. You just reply to
last 3 lines. After that, last 3 lines. The Central Commission may do away with his name from the panel. Immediately after getting the information that they have done, they will do away with the panel. His name will be deleted from the panel.
No. Suppose it is not deleted. We are accepting your argument that since I have not joined, you cannot de-panel me. Sorry, since I have joined, you cannot. That is the wording. Do away with the bill and Central Government do away with his name from the and will be deemed to have depaneled and recommend the candidate from the waiting list strictly within the validity period of the panel and waiting list. In your case, suppose the panel has proceeded, how do you overcome 17.3? If 17.3 is there, can the commission not argue that you are asking me to upload it to generate a third-party right, though the recommendation which we have issued is valid for 90 days? You answer our question to that.
I have understood.
Your counseling was on.
Those two candidates should never recommend. They never approached anywhere. They kindly extend our appointment letter or we are in
No, Mr. Badi.
Till date,
No. Our query to you, suppose we accept your contention. Suppose within 90 days, the person makes a you are going to fill up his vacancy in which he was recommended, but he did not join. Who reported? School told me. Your contention is once it is told to you, you put it up in the display board. This is your argument. But if the commission does so within 90 days, that would be curtailing the right of the person who has been recommended earlier. 90 days has to be given. And this is not yes, you can say that the rules should be amended. Obligation must be cast upon the school that yes, statutorily we are giving you 15 days time. Intimate within 15 days whether he has joined. If he has not done, nothing said and done, I will put it up in the server.
Suppose if the commission does not give 90 days of a candidate to a candidate.
If the 3, 4 and 5, Mr. Bari, if we all read 3, 4 and 5 conjointly one by one, so one recommendation letter shall remain valid up to 90 days. As and when a person receiving recommendation letter from the commissioner submits it to the school took it up and given appointment letter. That means function of the recommendation ceased as and when it has been accepted or deposited with the school. Then it will come letter of appointment. Letter of appointment will give a joining time.
Kindly think of a situation,
within now.
সেটা তো তুমি বলছো রেকমেন্ডেশনটা মার্চ করে যাচ্ছে উইথ দি
রেকমেন্ডেশনের ফাংশনটা সিজ করে গেল as and when letter of appointment is issued. Then letter of appointment will be issued giving a joining. And that joining time will be stipulated.
Kindly consider a situation.
It is stipulated. Let us read clause 4.
এই লাইনটা কিন্তু কোথাও নেই যে ওই অ্যাপয়েন্টমেন্ট লেটার ইস্যুয়েন্স
School authorities shall, on the basis of recommendation of the commission, issue letter of appointment to the candidate allowing joining time of not less than 30 days through such and such. Upon receipt of appointment letter from the school authority, candidate shall join the post within the stipulated period. Yes. The period stipulated by the school authorities in the letter of
Not a school authority, by the board, my lord.
uh,
Appointment letter will be issued by the board, my lord.
এটা up to commission. এটা letter of
না না এগুলো সব স্কুল অথরিটি রেকমেন্ডেশন লেটার সব স্কুল সব স্কুলকে দেওয়া আছে এগুলো বোর্ডকে দেওয়া আছে আপার প্রাইমারি সব ডাইরেক্ট স্কুল আপার
রিকমেন্ডেশনটা শেষ করে অ্যাপয়েন্টমেন্টের যেটা পরিণতি
My lord, kindly visualize a situation. My lord, suppose a recommendation was made, school authority issued appointment letter. A candidate asked the school authority, no, I will not join. In that case also, my lord, they will wait till 90 days. If nobody joined, my lord, then these three lines will hit.
We are, Mr. Badi, we are talking about a statutory violation. Your contention is right. Then we have to sit quiet, 90 days given, join, no join. Once I have been called for counseling, there is no compulsion upon them. Then the statute ought to have, we understand your problem, but the thing is, suppose today, if the commission, that person does not join, a case may occasion, suppose a recommendation letter issued on 3rd December, 30 days will be 3rd January, 60 days will be 3rd February, and 90 days will be 3rd March. Suppose after recommendation of the commission, board takes time and issues the appointment letter 1 day prior to 90 days. Visualize a situation. Then it was board's inaction. So the commission, where is the violation of the statutory provision by the commission? My brother's argument is in favor of it. My brother is saying that no, recommendation letter once issued, that will merge with the letter of appointment issued by the board. Then the commission cannot turn back and say that still I have to wait for 90 days. But subject to what we are discussing, this stipulated period, this will lead to multifarious litigation. No selection process will be completed. Everyone will join and find out another vacancy is there. Let me go and agitate that. Commission is a body constituted for the purpose of selection.
Rule said so, they have to include the vacancies. Rule is saying so, my lord. The post will remain on an unfilled
You are saying your counseling held in between
28 to 31.
28 to 31. Now you are saying the school informed the DI on 17. But when the school informed the
not DI,
informed the commission.
School directly informed the commission.
Directly informed where the received copy. I was trying to find out the receiving endorsement of
At the bottom, there is the stamp. At the bottom of the page, the receipt of the commission is there.
Receipt of the district inspector.
It's a inspector of school.
Taplita.
District inspector school. When the school is commission received, it is a letter dated 15. Yes. A letter dated 13. And teacher in charge signed on 16.
The school can say when the commission
Or
received
supplementary affidavit ta dao.
When commission received, commission received.
Go to the DI function.
Not joined has not given any
অন্য কথা
joined
যদি এখন মানে
did not respond to our phone calls. এই সময়টা স্ট্যাটিউটরি আছে যে আমার রেকমেন্ডেশন পিডিএফটা ভ্যালিডিটি থাকবে আমার মনে হয়
অ্যাপয়েন্টমেন্ট মেমো তার মানে একটা অ্যাপয়েন্টমেন্ট লেটার ইস্যু করে করেছে এগেইনস্ট দ্য মেমো এত
এই অ্যাপয়েন্টমেন্ট
লেটার ইস্যু হয়েছিল
9 ডিসেম্বর
2024
হ্যাঁ আর কাউন্সিলিং
কাউন্সিলিং হেল্ড অন
28 জানুয়ারি
25 month.
28 January 2000. The appointment letter issued
in 2024
on 9th December 2024.
এটা তো তুমি বলছো তাহলে যদি ধরো
30 days মানে 90 days এর ওই জন্য ওটা 9 তারিখের পরে ওকে ম্যাক্সিমাম টাইম দিতে পারে হচ্ছে 30 দিন
Till date, none of those candidates approached anywhere.
দেখুন not less than 30 days. এখন আবার 15 days করে দিচ্ছে সেইটা।
Those recommended
appointment letter দিতে পারেন।
হ্যাঁ, এইখানে দেখুন।
Not দেখা যায়, not এই যে
The school authority issue a letter of appointment to the allowing joining time of not less than 30 days through registered post with acknowledgement due. And upon receipt of appointment letter from the concerned authority shall join within the stipulated period. If the letter of appointment sent through registered post with AG, then at least 30 days time should be given.
Till date, none of those candidates approached anywhere that we could not join, kindly extend on
Till 30 days if it is sent through registered post with AD. And if it's received directly from the school authority, then time shall be given.
If those recommended candidates subsequently approached anywhere, well, then case would have been otherwise. But till date, none of those candidates approached. Well, kindly extend me, we could not join. This was the situation, nothing. Nobody has approached anywhere.
very good. In that case, it is an obligation on the part of the commission to display that vacancy. Where do you find? Show us.
Include the vacancy, my lord, yes.
That you will not find here. That you will find in the schedule. That schedule is at schedule 4. That schedule 4 is at page 88. 88. A schedule 40 বলেছিল না? Which was that schedule quoted in that?
That was a different rule. That was the headmaster's rule. This is the upper primary rule. More or less the same. Anything to this?
Shall sign a declaration. Page 89 to the.
My lord, possibly if it is at page 89, schedule 5.
No, it will be displayed. That word is displayed. ও অপশনটা দিল, এইটা ডিক্লারেশন দিয়ে যে আমি অ্যাকসেপ্ট করছি, আমার চয়েস अवेलेबल হচ্ছে
ডিসপ্লে কথাটা
এবং সেটা করেও জয়েন করে গেল। So at the time of option you sign a declaration.
Displayed. Yes, kindly see page 689.
Clause 5.
Clause 5, there it is mentioned.
Shall exercise selection medium recommended on the basis of list of vacancies of same nature at the point displayed at the time of option on the basis of query regarding allotment of vacancy. Shall arrange to display such allotment of vacancy against impanel subject wise. Here Mr. Badi's ground is that there were no further candidates in the wait list.
Maybe, but I have the 90 days which I have to wait. What my learned friend is trying to say, if the candidate had intimated the school in writing that I am not going to join, then I don't have to wait 90 days.
Mr. Dr. Patro, is it not a fact that the commission is taking advantage of this 90 days stipulated?
No.
Yes, because you come to know from the school that the person has not.
That is only a feedback that he has not joined, but he has not expressed in writing or in any other form that I will not join.
No, that he cannot say, because that is contrary to the declaration taken from him at the time of counseling.
Yes, but still, but not joining is also contrary to that declaration. If he gives in writing that I will not join, then I can treat it as a non-joining. If he does not mention it, if he does not give it in writing, then I have to wait for 90 days before I remove him from the panel.
75B, my lord.
75.
Central Commission gets information from any school that a candidate recommended for appointment has not accepted the offer appointment or joined the post within the stipulated period.
Stipulated period is 90 days.
Central Commission may do away with his name from the panel and will be deemed to have been depaneled.
Kindly see the recommendation letter. Page 7. Kindly see page 7 of the supplementary affidavit. The recommendation letter which my learned friend is relying upon, that this school is vacant. Here the appointing authority is the school, so the letter, the recommendation is addressed to the school.
It is not the board.
Not the board. Here recommending the appointing authority is the school.
Oh.
So it is.
Here it is appointing authority school.
Yes. Now kindly see.
Oh, this does not come under that rule. That headmaster.
The thing is, the 2018 rule came into force. In some of the selection processes, we sent the recommendation letters to the board. But upper primary, we have followed the rule strictly and sent it to the school.
Where, what you are showing?
Now kindly see the recommendation letter starts with sir, madam. Yes. Then kindly come to the second paragraph. The letter of appointment shall be issued by the above mentioned school authority to the candidate after verification of requisite documents relating to date of birth, academic, professionals, etc., etc., issued by the competent authority, allowing the candidate to join within the stipulated period in terms of Rule 17, Sub-Rule 3.
Answer is here.
Answer taken.
So that is the stipulated period, nothing else.
That means the school authority also.
Now this next paragraph is also very interesting.
In 17.
Now the next paragraph is also very interesting. Now the school is given an opportunity to give a feedback after 6 weeks.
Where is that?
The very next paragraph, this concerned regional commission shall be informed within 6 weeks. This is just for feedback. This is not part of the rule. Within 6 weeks from the date of issue of the recommendation of the action taken by the above mentioned school on his recommendation about joining refusal of the candidate. Now the candidate has not joined, nor has he submitted any refusal. So the 90-day stipulated period,
No, here the candidate, in this candidate was issued appointment letter on 9th of December 2024.
9th of December, yes. But this recommendation letter, the vacancy which he is trying to get.
Stipulated period as per 17th.
Yes, so if I give the stipulated period from 22nd November 2024, then it crosses the third phase of counseling.
So commission is to wait for the period as stipulated in rule sub-rule 3 of rule 17.
That is the provision.
You have joined the post, Mr. Bhatt. No.
Letter of
I am the candidate of Malta, but I have been recommended in the Midnapur.
But you signed the declaration at the time of
Thereafter, I did not join. But the school is at Midnapur.
But letter of appointment.
Then my learned friend should not have chosen this school.
I am the candidate of Malda.
He has blocked the school, but he did not join.
Section 9. Rule 9.
Section 9. Have a West Bengal School Service Commission Act have you brought?
My lord, it is not with you.
Section 9 is the recommendation for appointment to the post of assistant teacher in pursuant to this section 9 of the letter.
This recommendation for appointment is pursuant to section 9. Section 9. Okay.
Notwithstanding anything contained in any other law for the time being in force, or in any contract, custom, or usage to the contrary, appointments to all posts of teachers in school shall be made by the managing committee by whatever name called, or by the ad hoc committee, or by the administrator, if any.
Yes.
Where there is no managing committee, of the school on the recommendation of the regional commission having jurisdiction. Subsection 2, any appointment of a teacher made on or after the commencement of this act in contravention of the provisions of this act shall be invalid and shall have no effect, and the teacher so appointed shall not be a teacher within the meaning of clause P of section 2. That is all that is stated.
রিকমেন্ডেশন ছাড়া কাউকে অ্যাপয়েন্টমেন্ট
অ্যাপয়েন্ট করা যাবে না তাহলে দেখি
93
There is no 3.
ও কেন কলেজ সার্ভিস কমিশন নাকি হতে পারে there is a provision once a recommendation was given to you, you accept it, thereafter you cannot turn back and it will be dependent. That provision.
না সেরকম প্রভিশন নেই 90 ডেজ পরে ডিপেন্ডেন্ট হবে সেটা 17 নেই ডিপেন্ডেন্ট হয়ে যাচ্ছে 90 ডেজ তো ওয়েট করতে হবে
একবার একটা স্কুলে চয়েস করে ফেললে আরো অন্য করতে পারবে সিজ হয়ে যাবে যেটা আমরা ওই মামলাটাই কনসিডার
কিন্তু এখানে তো ইট ইজ ইমিডিয়েট কেননা ওয়াজ রিকমেন্ডেড সিজ হওয়ার প্রশ্নই তো আসছে না কেননা ওর রিকমেন্ডেশনটা যেদিনে ইস্যু হচ্ছে তার আগে 90 দিনের আগে প্যানেলটাই এক্সপায়ার করে যাচ্ছে
এটা আছে যেটার জন্য আমরা কলেজ সার্ভিস কমিশনে গিয়ে
ওইটা তুমি যেটা বলছো সেটা ওই ডিক্লারেশনের ওয়ার্ডিং পেপার selection and acceptance as per is available at the time signs a declaration of selection and acceptance refuse to exercise this option candidate shall have to sign a declaration of selection and acceptance of the school as per his choice available. তারপরে refusal to exercise option in respect of selection and acceptance of any school available.
তারপর পাতার ছিল
তার মানেটা কি available at the time as during counseling. তারপরে একটা বলতে the qualified absentee যদি কেউ absentee থেকে থাকে directed to contact the commission for getting recommendation letters within 10 days from the date of issue of the letter in the city shall be treated as cancelled without any further defense.
This is
Absentee. এখানে তুই ডিক্লারেশন সই করে বলে দিচ্ছে 7B-টার মানেটা কি বলতো
7B হচ্ছে রিফিউজাল যদি করে তাহলে সেটাও ডিক্লারেশন দিয়ে যাওয়া দেয়
জানানো তো নয় এটা তো শালা একটু সাইন এ ডিক্লারেশন এট দি টাইম অফ কাউন্সিলিং
যদি ও রিফিউজ করে টু এক্সারসাইজ অপশন ইন রেসপেক্ট অফ সিলেকশন সেখানেও ডিক্লারেশন দিতে হবে অ্যাকসেপ্টেন্স অফ এনি স্কুল সেটাও রিটিন
Refusal or acceptance is different.
ফর্ম থাকবে ফর্মে ওই স্কুলের নামটা লিখে দেবে ও সই করবে এবং ওয়ান্স ও অ্যাকসেপ্ট করে নিল মানে ও আর অন্য কোনো স্কুল অ্যাকসেপ্ট করতে পারবে না ওর পাওয়ারটা সিজ হয়ে গেল ব্লক হয়ে গেল এরকম দেয়ার ইজ এ কলেজ সার্ভিস কমিশন এরকম একটা প্রভিশন আছে
এখানে তো তাহলে ভ্যাকেন্সিটা হচ্ছে যে কমিশন জানা সত্ত্বেও ভ্যাকেন্সিটা দেখায়
কিন্তু সেটা দেখাতে পারছি না কমিশন
পেয়েছে
আর কিছু করার
সরি
My lord, in an identical situation, my lord, this honorable court passed a judgment, my lord, Dr. Patra appeared, my lord, on behalf of the commission. Commission accepted the contention of the petitioner. They accepted the judgment and they have recommended the candidates. Perhaps this judgment is in Lordship's file because I supplied it before the coordinate bench. Can you see the Krishna Chandra Hor judgment?
How come the judgment on this page?
Post of headmaster.
Yes, rules is same.
No, there was a mistake which we have admitted. That was done by mistake. The vacancy was with us, it was not shown. Totally different facts.
Oh, you admitted it?
Yes, yes. Even in our affidavit, we have stated.
Let me place that judgment. Let me place.
Loose. Actually,
may I place it, my lord?
Just 1 second.
My lord, kindly see page 4, the last paragraph of the judgment. It was our mistake. We had the vacancy, we did not display it.
Sorry, Mr. Bhatt.
No, kindly may place it. That is not the case. Kindly allow me to place it. This judgment only. Kindly,
What?
May I place?
When we have stopped you.
Say identical fact,
When we have stopped you, you say we don't stop the council.
Petitioner was a successful candidate for the post of headmaster in state level selection test. The petitioner on November 25 was recommended by the Central School Service Commission to the post of headmaster at one Torial High School, Dokhin Dinajpur. The petitioner did not join at the said school and filed this REET application on January 3, 2020 during the subsistence of the panel. The petitioner contains that since the recommended headmaster did not join at the Balurghat Kobititto Vidyaniketan, the commission should have mentioned this vacancy before the counselling took place in which the petitioner had participated and received the recommendation at Torial High School. The specific case made out by the REET petition that the one Krishnanath Goswami, though was recommended for Balurghat Kobititto Vidyaniketan, and since he did not join there, the vacancy had cropped up. To the Krishnanath then was recommended for a different school, namely Borisha School at Kolkata. Though the instant REET petition, the petitioner paid for fresh recommendation for the said vacant post at headmaster at Balurghat Kobititto Vidyaniketan. Mr. Wasaf Ali Mondal, learned advocate, appears for the petitioner. He submits that not reflecting the vacancy at Balurghat Kobititto Vidyaniketan school for the post of headmaster at Krishnanath did not join there. The Central Commission acted in an illegal and arbitrary manner in violation of the relevant statutory rules and the rule of the relevant selection process. Had Balurghat Kobititto Vidyaniketan been indicated before the counselling in which the petitioner had participated, the petitioner could not have easily opted for the same. Thus, the petitioner deserved to receive a recommendation and consequential appointment at said Balurghat Kobititto Vidyaniketan, which is nearer to his residence. Dr. Patro, learned advocate, appeared for the respondent number 4 and 5, placed reliance on the stand of the commission, as would evident from the affidavit report affirmed on such and such date. Now, what they have stated in the affidavit. One Krishna Chandra Hor filed a REET petition before this honorable court. On going through the REET petition, it came to knowledge that the petitioner was a candidate of first SLST, a selection process of the post of headmaster. It appears from the record that the name of the REET petitioner was included in the waiting list as serial number 756, male-female category, and he was called for third phase counselling on 25th November 2019. He attended the counselling and opted for Torial High School, and recommendation letter for appointment was issued in favor of the REET petitioner on 25th November. Now he has claimed for recommendation for appointment in Balurghat Kobititto Vidyaniketan, which was included in the final vacancy list of first SLST headmaster 2017. The vacancy of the post of headmaster of Balurghat Kobititto Vidyaniketan was included in the final vacancy list. It appears that the post of headmaster of Balurghat Kobititto Vidyaniketan has been running vacant on and from 29/8/2019, and the vacancy should have.
Yes, so they got the information. Here they got the information. As such, it was in the vacancy list. That is why we said that I have committed a mistake. That was recorded in page 4 in course of submission. Dr. Patro have confirmed that it was really an inadvertent and bona fide mistake on the part of commission by not reflecting the said vacancy in the final vacancy list for third council.
In this case, that is one candidate was recommended, my lord. Can you see? Not that case, my lord. In the
for this purpose.
On the page 2, first paragraph, can you see? That vacancy of one candidate was recommended. He did not join. Thereafter, it was included.
Right. It was included. Here, it is not included.
That is my case. Why they have not included?
They did not include it due to Rule 17. you throw this argument of you satisfy us, because this can never be conceptualized that a selection process will, you can argue that commission taking advantage of that 90 days in spite of knowing has not put it in the list. Had it been a case that 90 days has expired, then also the person did not join, and that corresponded with the display board which is shown to you, vacancy listed, it will come. Had it been a case that within beyond 90 days this was not acted upon, then the vacancy he ought to have included. More so, the proviso says that commission may give further time for validity of the recommendation. কোন দিক দিয়ে বেরোবে?
Kindly grant me 1 minute time, I will prepare myself.
আবার কি 1 minute time?
Kindly, kindly, my lord. My lord, in this case, my lord, in this case also, my lord, without waiting for 90 days.
Better case.
But in this case also, my lord, without waiting for 90 days, my lord, they have included the vacancy, my lord.
Where?
In this case, my lord, I am placing this judgment, my lord.
That is the mistake they committed.
The mistake.
Yeah.
First round of counseling, you recommended one candidate. He did not join, my lord. Kindly see, this is one specific case, my lord. The Balanghat committed the one candidate was recommended. He did not join in the first round of counseling, my lord. That cannot be the mistake. My lord, kindly see, my lord, first one candidate was recommended in that post, my lord.
The mistake was
join. Thereafter, that vacancy was included in the third round of counseling. That was not included. That's why court directed him to include it.
Okay, Mr. Bari, you just show
the
any
mistake on our
document,
part was that the
any
vacancy
document
came back, but we did not show it.
that before holding counseling, this fact was
But in this
brought
case,
to
is
the
there
notice
case,
of the
but they did not get any information.
Yes, that
Yes, that is the case.
That is the entire case.
Direct the school authority to furnish information when they sent the vacancy. When they intimated the school service commission.
Non-joining.
Kindly, my lord, direct the school authority, my lord. My lord, kindly, my lord.
That is immaterial, Mr. Bari. I can appointment letter issued to me. I do not join. Suppose appointment letter 30 days come, I do not join.
My lord.
So but to block that vacancy, I have to represent to the authority that you extend it for a valid further period of 60 days so that I can join. These circumstances cannot be ruled out in every case.
These recommended.
Sorry, Mr. Wadi.
The
Present appeal has been preferred. Challenging.
They were approached anywhere that we could not
90 days.
90 days.
The case would have been
And-
otherwise.
And in
those
case,
candidates,
when it would be sent through registered post, 30 days. If not, this time is not available to the school authority. School authorities should approach the commission that you extend the time.
case would have been otherwise if they subsequently claim they are
Oh,
there.
Mr. Badi has also placed reliance upon a judgment, upon an order passed by
Unreported.
an unreported
Decision.
order, an unreported decision. In the case of such and such being WP numbers, in our opinion, the said judgment, the said order is distinguishable on facts, inasmuch as in the
And 15, 13. The Shomala 14 and 15, the hearing has to commence. Consistently, let it be 14, 15 first, thereafter.
What?
13, 14, 15,
Huh.
14 and 15, when hearing has been started. The Shomala let
Hearing started.
Piyush Chaturvedi.
Oh, Piyush Chaturvedi.
Started the hearing.
Huh.
So it will be easier if the Lord says takes up 13 after 15.
Today we cannot take it up, Mr. Badi.
Tomorrow.
No, let it appear. Let us see how this.
Let it appear. It will, computer will arrange accordingly.
Computer है तो अपन किसी manually